by simply reading some of these articles that I have prepared, you will get an idea of my concept as to professionalism and ethics. At the outset, I'd like to read this that I forwarded to Ms. Jean's committee. I am honored to have been asked to address you on the topics of professionalism and ethics. They have been of interest to me for as long as I have practiced law. On numerous occasions, it has been my pleasure to have been asked to make related remarks to law school groups and to church groups. You will find attached to this paper copies of some of these remarks. You may find them to be of interest. Time permitting, other papers will be alluded to. For the purpose of our discussion, we can choose some among several of Webster's definitions of professionalism. Paraphrasing, we can say that a professional is one who is engaged in one of the learned professions requiring a high level of training and proficiency, characterized by and conforming to high ethical standards. There must be extreme competence in the occupation, and there must be absolute adherence to a high moral code. In this regard, ethics and professionalism are intertwined. Without the one, the other cannot exist. Further citing Webster, we learned that the learned professions are these: theology, law, medicine, and I have added teaching. Webster elaborates by saying the term can be applied to a broader spectrum to any profession in the preparation for which or practice for which academic learning of a high order is required. Now, it is not snobbish for us as lawyers to acknowledge the fact that we do have a high degree of learning. That is simply a fact that is established. But I add to that, there must be a sense of calling to constitute a profession. You can be highly educated, but if you have no sense of calling, you're not a professional. Without this sense of calling, the lawyer is not a true professional, no matter how skilled or learned at the trade he or she may become. The law would then indeed become a trade and not a profession, if there were not the sense of calling attached. L. McGantry showed us all that the minister without a sense of calling and adherence to high moral standards is certainly no professional. A physician who is not inculcated with and driven by the Hippocratic Oath is not a profession. A lawyer who is simply in it for the money or for the inflation of his own ego is not a professional. Ethical conduct is indeed an essential ingredient or part of professionalism. Without adherence to high ethical standards, the skilled advocate is no more than a shyster. She is certainly not a professional. Webster tells us that ethics deals with principles of what is right, distinguishing good from bad, right from wrong, moral from immoral, or amoral. For those of us who have been fortunate enough to have been raised right, we know these standards. For those who are not so raised, it is time they learn. I've added this other also, civility and professionalism. Civility, too, is a part and parcel of ethics and professionalism. For those who have been raised right, you know exactly what it is to be a lady or a gentleman. There needs to be no elaboration, no discussion. You know what it is. Civility is part and parcel of professionalism and ethics. Civility simply describes the practice of being civil or courteous to clients, to adversaries, to witnesses, and to the court. You are not required to be a Casper milquetoast. You may be aggressive, you may be assertive, you may be staunch in your advocacy. You must, however, be civil. In the course of my observation over the years, most attorneys and most judges with whom I have come in contact have been true professionals in all of these categories. Most have been highly trained, most have been skilled in their craft, most have felt and followed a sense of calling, most have conducted themselves in accordance with high ethical standards. The lack of civility is the only one of these essentials that I have seen most often, but rarely that. To me, this lack of civility is unethical and unprofessional. The lawyer who lacks civility, though he may be skilled and he may abide by basic rules of ethics, is nothing but a boor. A judge who lacks civility is a bullet and a tyrant, because obviously there's no way to defend oneself from an uncivil judge. Concluding these remarks, your education is a fact accomplished. You are the beneficiary of a skilled calling. Your skill is of a high order and improves each day. You can certainly develop a sense of calling. There is not one of you who does not know how to behave as a lady or a gentleman. You will never have a problem with ethics if you follow the old axiom. If you ask a question, the answer is no. And that cannot be impressed on your mind too strenuously. If you are pondering, is this ethical or is it not ethical, don't do it. Don't call up the street to the state bar. Don't talk to a judge. Don't talk to a fellow lawyer. If you have misgivings about a course of conduct, don't do it. Now, you do need to know whether it is an ethical question or another type question. Sometimes questions arise, and it might not be an ethical matter. But if it is a true ethical matter, then if you ask the question, the answer is no. If you will abide by that, you'll never have a bit of trouble with ethics. Now, Judge Manning has alluded to the Wake County Bar Creed. Judge McCrodden and I and several others, Alice Roman, she may not be here now, we had a meeting one night or one afternoon. I think it was in Reverend Bailey's law office, I'm not sure. And they asked us to send a letter. And I wrote a letter to Carlin Food. Here's the letter. Dear Carlin, in response to your inquiry as to my thoughts on the meaning of professionalism and the practice of law, I submit these observations. In the outset, it should be remembered that the practice of law is a profession and not a business. Law, like the ministry, medicine, and teaching, must be service-motivated rather than profit-inspired. While it is not amiss for a lawyer to prosper, if wealth is his aim, he becomes nothing but a hustler and not a lawyer, and non-professional. Integrity is an absolute. Any compromise with integrity is unacceptable. Civility is an essential, with adversaries, with clients, with bench, and with bar. The lack of civility renders the practitioner a boor and a non-professional. Professionalism for the lawyer calls for community and civic involvement outside the bar and for contributions of time and effort towards bar undertakings. In his novel Guy Mannering, Sir Walter Scott, who was a lawyer, observes, a lawyer without history or literature is a mere laborer. With them, he can call himself an architect. And of course, that relates to the higher skill. I see too many capable lawyers who are too busy making money to contribute time and effort to community affairs and time and effort to bar association activities. As capable and as financially successful as they are not, in my opinion, true professionals. Based upon that letter and other things, the Wake County Bar Association published its creed. Now, I've talked to church groups and student groups, and I think I have about 10 more minutes, Katherine, is that correct? 15? Well, I can go on a lot longer, but I won't. There's some religious overtones in some of these papers that I'm going to read you. I'm not conducting a revival, but bear in mind, these were addressed to religious groups. I was called upon, I've talked to church groups, and one time I educated church people. And they asked me to talk on this question. Can a Christian practice criminal law? The same question from these people might have said, can a good Jew practice criminal law? In other words, the criminal law in the concept of some of these young people is so tawdry that they felt it was not appropriate for a Christian, or as I say editorially, a good Jew to practice criminal law. Here's what I told those students. History, the Bible, and experience can help us answer this question. Are the police of Chapel Hill always right? Is the sheriff of Orange County always right? Is President Spangler always right? Is Dean Wagner always right? Should every person accused of a crime in Chapel Hill be sentenced to prison without a trial upon a policeman's accusation? Should persons suspected of serious crimes be lynched? Should Rosa Parks be forced to sit in the back of public buses in Montgomery? Should printers be executed for printing the Bible? Should Puritan fathers be allowed to drive Roger Williams out of Massachusetts because of his religious beliefs? Should Spanish inquisitors be allowed to execute Jews? Should you be expelled from law school because you criticize your congressman or your nation's president? If your answer to these questions is yes, then I am wasting your time, and you should not be in law school. Shakespeare, with tongue-in-cheek, wrote, "First, let us kill all the lawyers." This is taken out of context and is a favorite non-lawyer jibe at the legal profession. Adolf Hitler said, quote, "I look forward to the day when any German will be ashamed to say, I am a lawyer," unquote. The dichotomy to be addressed is tyranny and the male fist on the one hand, and the rule of law and freedom on the other. Now, this is beyond this paper, but it's a quote I wanted to insert while it was on my mind before forgetting. Justice Harlan F. Stone, Chief Justice of the United States Supreme Court and former Dean of Columbia Law School, said, in every trial, Magistrates Court to the U.S. Supreme Court, the law itself is on trial. That is a rule that every true professional should never forget. The law is on trial at every step of the way. And that is your true calling. The rule of law, your duty to the rule of law is your true calling. I'm reiterating Webster here. I'll skip him again. Wherein lies the call to practice law? The rule of law. Insofar as civil law is concerned, the systematic rules and process of an orderly society protect us all. A legal practitioner who is a true professional serves this mandate and answers that call. Our personal rights and responsibilities and our business activities are delineated and protected. Without this rule of civil law, the law of the jungle controls, where might makes right, where the strong devour the weak, where chaos reigns, leading inevitably to tyranny and totalitarianism. Since much of my focus has been in the field of criminal law, I humbly and thankfully acknowledge the great contribution to our society that the criminal bar renders. Your very presence here this morning is a direct result of safeguards found in the Bill of Rights and elsewhere that have been honed and refined in the crucible of the briefs and arguments of criminal lawyers through the ages. Your right of free worship is assured. My right to speak to you is guaranteed. Our mutual peaceful repose in our homes, businesses, and personal lives, free from interference by unreasonable government abuse, is made possible. These American blessings are ours because of the strivings of criminal lawyers from Magna Carta to this day. Bibles have been banned, witches have been burned, citizens have been lynched, all by popular demand. Through the ages, opposing such popular frenzy have been the criminal lawyers and the courts, presided over by strong judges. The Judeo-Christian heritage uniquely reveres the individual. Our Bill of Rights is the ultimate legal safeguard of this reverence. Your right to worship, bear in mind I was speaking to a church-oriented group. Your right to worship, your right to speak, your right to preach or publish, your right to differ, your right to criticize your leaders, your right to a fair trial in court, your right to counsel, your right against self-incrimination, your right against unlawful searches and seizures. The list goes on. These privileges are so basic that we are blasé about them. Don't be. Without your Bill of Rights, they wouldn't exist. Without the efforts of generations of criminal lawyers, what is dear in the Bill of Rights would long ago have been eroded into sound and fury, signifying nothing. But lawyer, the Christian asks, and how many times have people in my church and elsewhere asked me this question, but lawyer, how can you defend that man when you know he is guilty? My friend, you are talking about moral guilt. It is blasphemous for us to assume the role of judge of another's moral guilt. Only God can do that. Man can only judge legal guilt. Magna Carta, the common law, our Constitution, and its Bill of Rights have combined to prescribe the means for judging legal guilt. The criminal lawyer is the one who assures that rights will be protected. He or she assures that the judge will apply the law properly, that the prosecutor follows the rules of evidence, that the jury hears the evidence and renders a just verdict. The criminal defendant stands alone against the power and the majesty of the state. Only his lawyer is at his side. The defendant is lonely and afraid. His lawyer is with him. The defendant's innocence is presumed. Only by guilty plea upon the advice of counsel or guilty verdict after trial with due process is the defendant in fact guilty. To assume moral guilt at any point is blasphemous. To assume legal guilt without due process is contrary to our heritage of liberty under the law. The defendant's lawyer assures that this due process is followed. The defense lawyer renders a sacred service whether there is acquittal. This is important for all lawyers to remember. The defense lawyer renders a sacred service whether there is an acquittal, a conviction, or a guilty plea. His or her insistence upon due process and a fair hearing contributes in every case to the whole body of the common law. This contribution is no less valuable when the criminal lawyer does not prevail. By the insistence upon a fair trial, the sanctity of the system is enhanced and made more secure, and the trial of the system is assured, as Justice Stone insisted, when the defense lawyer does that. I feel a high sense of calling when asked to defend an accused. It is my belief, this is to a church group, it is my belief that Christ speaks to us when we stand with the one who is alone and afraid. I know that we are doing God's will when we demand due process under the law. I know that without the efforts of criminal lawyers, mistaken convictions would be commonplace. I know that without the efforts of criminal lawyers, we would have listen to this, we would have a most efficient criminal justice system which ignores Magna Carta, which ignores common law, which ignores the Bill of Rights, and which bans Bibles, burns witches, and hangs heretics. The criminal lawyer is answering the call from Amos of old. Let judgment roll down as water, and righteousness as a mighty stream. So this is my calling, in which I believe with all my soul and my being. Micah said it far better than I. Do justice, love mercy, and walk humbly with God. Now, I said that to church-oriented group. And I say with a smile, they never have asked me to come back. So, but that's still my view. I spoke to Katherine said I've got about 5 more minutes. I want to read up one other thing if I can find it. Let it never be forgotten, though it often is. How much time we got, Captain? Let it never be forgotten, though it often is, by the public and lawyers alike, that the practice of law is a high calling. It is indeed one of the great professions. And then I quote Webster again. I believe that if a lawyer has no sense of calling, then he never can be great. He may be a moneymaker. He may be a successful practitioner of the trade, but he will never be a true professional without this sense of calling. He must have a reasonable knowledge of current law trends. More important, he must have a feel for the general concepts of law and the philosophy of legal tradition. He must be tough, not coarse or crude. Even gentleness and certain gentility is consistent with the kind of toughness needed. This toughness is synonymous with self-confidence, the courage of conviction, ability to take criticism, ability to make decisions, and the fortitude to lose. One of the highest compliments I ever heard paid a lawyer was paid by the late Governor J.M. Broughton to my father many, many years ago, and he said this, Mac, you are not afraid to lose a case. To me, that is a great, great tribute and a great compliment to a lawyer. It means simply that the lawyer will undertake to do the job to the best of his ability, try as he can, and if he loses, so be it. He's done his best. He must have empathy for his client. He must have compassion. Yet with both, he must retain objectivity. Knows coffee with the client. It should be remembered that relatively few persons represented in criminal court are vicious or mean. Most are just ordinary people who have wittingly or unwittingly misused. Usually they are frightened. Oftentimes they are embarrassed. Always they need an advocate with empathy, compassion, but with objectivity. Some are vicious and mean. They too deserve your best. If their rights are denied, then the rights of all will be denied. Never forget that the courts are judging legal issues, not moral questions. In the Judeo-Christian tradition, only God is to judge morals, as Portia says in The Merchant of Venice. Remember this, that in the course of justice, none of us will see salvation. All of you remember that. Would I see salvation if justice rule my life? No. It takes compassion, love, consideration. So it ill behooves me to judge another's morals. How often, though, is the criminal lawyer asked, how can you represent him when you know he is guilty? Of course, the well-meaning do-gooder who asked this question is passing moral judgment. In blatant defiance of the biblical mandate, judge not that ye be not judged. My philosophy then is simple, and I'll close with this. I am proud to be a practitioner of criminal law. I haven't a doubt that it is a high calling. Every time you give uplift to a downtrodden human spirit, you're doing something almost divine. Every time you do a thorough job, whether the plea be guilty, not guilty, or no contest, you are strengthening the adversary system. Each case that you handle becomes a part of the body of the law, a segment of our own common law. Thus, when you try a case well, even though you lose, your contribution is great. Our constitutional rights are respected. In conclusion, well, I've concluded.
currently in an area where they're subject to be ticketed after 4 o'clock, so if that might be your car, you might want to investigate that. Our next speaker is Honorable Elizabeth G. McCrodden, who is formerly a judge of the North Carolina Court of Appeals and who is now engaged in the private practice of law. Judge McCrodden is going to invite us to rethink the adversary ethic. Thank you.
I'd like to say a couple of things first. It has just been brought to my attention that along with Mr. Ainsley, Katherine Jean, who has chaired this committee and worked very hard to put this together, also was responsible for paying for this location and setting this up for everyone. So I think she deserves a fine round of applause. I also want to thank the people who are sitting in the upper level because you have informed me that I need new glasses. I just see blurs on faces up there. One final note before I get into the substance of it. Katherine, you neglected, I noticed that you had a long skirt on. You neglected to tell me that Judge Manning was going to talk about short skirts and court, and fortunately I don't have 2/3 of a thigh to show, so I don't have any problem with that, but I will know next time. My topic is about zealous advocacy. And I wrote this paper, so I don't want anybody to think that there's a ghostwriter out here. I'll take full credit for any criticism you want to give me about it. I want to start out by reading a part of my paper. I'm not going to follow my paper, by the way, so I hope you won't be miscombobulated by that. This came from an article in Theology Today where I'm continuing Mr. McMillan's bent on this. A further problem in ethics has arisen with the increasing complexity of modern industrial society and the fact that many people spend the greater part of their active lives in the organizations which it has produced. Thus, the need has arisen for codes to regulate the behavior of people within these organizations, and these codes are called professional ethics, though they are not ethics in the classical sense of the word, but rules for the behavior of business people, lawyers, doctors, in their respective professional organizations. A glaring example of the dubious ethical nature of these ethics is to be found in the war guilt trials following World War II, when persons accused of atrocious acts pleaded in their defense that they were only obeying orders, and obedience to the order of superiors is the first commandment in military ethics. It's on the basis of this that I'm asking us to reconsider the adversary ethic that we all practice. I note in my paper that I think adversary ethics is an oxymoron, and to some extent one contradicts the other. This is brought home by the fact that there have been many criticisms of the adversary ethic, many uses of it that have been inappropriate. Anne Strick, who wrote the book Injustice for All, said, "I believe that our adversary legal system, its assumptions and values, is one of the major taken for granted, practically never questioned institutions of our culture. More, I believe it is an anachronism relic of a primitive way of seeing and thinking about the world. Indeed, our commitment to adversary approach demands that we refuse much of the best knowledge and behavior of our 20th century and go backwards, centuries back, to ordeal and magic." Anne Strick was a layperson who witnessed our court system as a juror, plaintiff, defendant, witness, and just as an observer. She is not alone in her criticism of the adversarial process. During the 1970s and 1980s, many lawyers and jurists began to question the efficacy, indeed the ethics, of our adversarial process, including then Chief Justice Warren Burger. Chief Justice Burger suggested that the adversary system as presently constituted denies justice to litigants, undermines faith in the courts, and raises the specter of the breakdown of judicial machinery. I want to turn now to what has been called Republican legal ethics. And Republican, as many of you will know, I don't advocate too many Republican things. So Republican is with a small r, and it refers to a 19th century development in legal ethics. The underlying basis of Republican ethics was that the professional, whether doctor, lawyer, or teacher, serves private needs in reference to large cultural or communal purposes. Hence, for example, lawyer David Hoffman, and listen to this carefully, in an 1836 statement of 50 resolutions stated, "I will never plead the statute of limitations when based on the mere efflux of time. For if my client is conscious he owes a debt and has no other defense than the legal bar, he shall never make me a partner in his knavery." Thomas L. Schaefer, who is a professor of law at Washington and Lee, states that American lawyers who taught law before 1850 taught their students that it was wrong to argue for a legal principle that did not serve the common good. Professional narrowness was, according to the Republican ethicists, immoral in certain situations, normally those in which there was no recognition of a public moral sense, a sense of the common good. Despite assertions to the effect that the adversary ethic evolved in England as early as the 17th century, Schaefer attributes the date of its emergence on the American scene to the end of the 19th century, specifically about the time that lawyers representing the robber barons pushed advocacy beyond its earlier bounds. In New York City, clients involved in the robber baron scandal fled the jurisdiction to evade injunctions. They bribed legislators and were possibly involved in the commission of murder. Their attorneys, including David Dudley Field, brother of the Supreme Court Justice, set out to frustrate the legal process by playing judges against one another, taking advantage of a procedural code that he himself had drafted. The other three events which Schaefer believes contributed to the adversary ethic were growth for the practice of law, or larger law firms, the formation of the first local and national bar associations, and the appearance of the first code of legal ethics. To emphasize the change that was taking place in legal ethics, Schaefer notes the response of prominent laypersons who were concerned with what was occurring with the robber barons. Henry Adams, who was a novelist and a social critic, publicly noted their moral disapproval of what the lawyers were doing. He and others contended that the behavior of these lawyers betrayed the personal public responsibility that Adams' ancestors had accepted as the burden of being American lawyers. In an argument we would consider unique today, Adams stated that public opinion was being disregarded, again revealing their belief that the lawyers for the robber barons were not cooperating with the public conception of the common good. He wrote, "What was crucial," or this comes from Schaefer, "what was crucial if Republican social ethics were to remain plausible was the claim that Adams and editorials in the New York Times made about the relevance of the lawyer's behavior in the robber baron cases. The issue was not so much that the behavior was wrong, but that its rightness or wrongness was a matter of public concern. It was not intrusive for newspaper writers to question what lawyers did for clients because the community was within legitimate limits when it called upon lawyers to account for what they did for clients and to do so publicly. The Republicans' attempt at fraternal correction were functionally not so much condemnations as invitations to discuss the common good." The lawyers' response was, of course, that the matters they and their clients had and discussed were private moral matters, and that would be probably our official response today. I'd like at this time to let you think about the Republican legal ethic with a couple of examples. Here's the inquiry. Attorney represents client, a claimant for Social Security disability benefits. attorney files a request for an administrative hearing before a Social Security ALJ. Social Security hearings before an ALJ are considered non-adversarial because no one represents the Social Security Administration at the hearing. However, prior to the hearing, the Social Security Administration develops a written record which is before the ALJ at the time of the hearing. In addition, the ALJ has the authority to perform an independent investigation of the client's claim. Prior to the hearing, attorney writes to the claimant's treating physician and asks for a letter stating the physician's opinion about the claimant, about the claimant's disability. This comes out of our lawyer handbook, and for some reason all the apostrophes are periods, so I have difficulty reading it. In a responsive letter, the physician indicates that she believes that the claimant is not disabled. Does attorney have to submit the adverse letter from the physician to the ALJ at the hearing? The answer, the opinion is no. Although it is a hallmark of good law, this is the state bar's answer, not how Republican legal ethics might have considered it. Although it is a hallmark of good lawyering for an advocate to disclose adverse evidence and explain to the court why it should not be given weight, generally an advocate is not required to present facts adverse to his or her client. It goes on to talk about how in an ex parte hearing, Rule 3.3D of the Revised Rules of Professional Conduct require the lawyer to be forthcoming about all information that may affect the judge's ruling. Nevertheless, a Social Security disability hearing should be distinguished from an ex parte proceeding, such as an application for a temporary restraining order in which the judge must rely entirely upon the advocate for one party to present the facts, and so on. Queried how Republican legal ethics would have responded to this particular question. Second inquiry. Client was charged with driving while impaired. Attorney A represented him at trial where client was convicted. At the sentencing hearing, the prosecutor informed the court that client had no record of prior convictions for DWI. Attorney A and client were aware, however, that client was convicted of DWI in federal court, but the federal court failed to forward information regarding the conviction to the North Carolina Department of Motor Vehicles for inclusion in client's driving record. Therefore, when the prosecutor checked the driving record, he found no record of the prior conviction. At the sentencing hearing, attorney A and client remained silent when the prosecutor informed the court that client had no prior convictions for DWI. Neither attorney A nor client made any affirmative representations to the court about client's driving record. The judge sentenced client to punishment level 3, which can only be imposed if the court determines that the defendant has not been convicted of a prior DWI within the previous 7 years. Was it unethical for attorney A to remain silent when he heard the prosecutor give erroneous information to the court? Opinion. No. It was not unethical for attorney A to remain silent. The burden of proof was on the state, and so on and so forth. The opinion does go on with a second inquiry, which talks about the client wanting a limited driving privilege and having to make application, and it does say that the lawyer in that situation would not be able to help him fill that out because it would imply that he had no prior DWI, and that would be a more active and unacceptable action on behalf of the attorney. On the first opinion, though, in terms of the silence, I teach professional responsibility at UNC, and there's a professor of that, I don't even know who it is, but he or she has on her door a bumper sticker that says, "Is silence complicity?" And I would think that perhaps it is in many cases. Now, let me move to prosecutorial conduct. Very often we are asked, and I think Mr. McMillan kind of referred to being a criminal defense lawyer. The shoe is on both feet, so to speak. You've got problems on both sides, and I have recently been involved in an appeal of a death penalty case, and let me say at the outset that it was not tried in Wake County, nor are any of the judges on the panel involved in this case, which I will not identify to you. But I want to just tell you a little bit about what the prosecutor did in that case. It was a case in which they were going into the sentencing hearing, and one of the problems that the defendant had was the possibility of mental retardation. And the defense had hired a clinical psychologist to examine him and to bring forward to the court an opinion as to whether the defendant was clinically, or excuse me, was mentally retarded. And here is some of the cross-examination of the doctor. I'll try to keep his name out of this so as not to give you who it is. There was some discussion about whether there was an organic problem with the defendant that may have caused his mental retardation. The prosecutor on cross-examination asked the doctor whether you, doctor, stumbled a bit when you came off the stand to go and retrieve this document. That would not be any evidence of any organic impairment. Now, and he goes on to say, would it? And then hold that for a while, because when we get to his argument, we'll go back to this. Then later he says, when he's talking, the doctor has a chart, and he's showing where the mother of the defendant fell in that chart and where the defendant fell in terms of mental retardation. And here's the question by the prosecutor. And could you put a mark where a person is moderately retarded? And the doctor does so, and he complies. What about severely retarded? They'd be just over here a little further, and the doctor indicates. So they're all kind of lumped right in there in one percentile. This is the prosecutor again. Where would you put yourself? The trial court judge sustained the objection, but the problem, I think, is there. Later in his cross-examination of the same doctor, he asked him whether he had seen or consulted with another doctor, a Dr. William Mitchell, whose name was on a report that was done at Dorothea Dix. And when the doctor indicated that he did not consult with this Dr. Mitchell and did not know who he was, the following occurred. This is the doctor. You want me to look through and find the court? Yes, if you'll find Dr. Mitchell as if it appears there. The prosecutor, whose name shall remain nameless, I'll withdraw the question if he doesn't know where it is. The court, all right, thank you. Mr. Caldwell, it's a waste of time. Objection sustained. Now, even though their objection is sustained, here's a prosecutor who is trying to imply that this doctor doesn't know anything about the report. Well, it turns out that the Dr. Mitchell had done an x-ray of defendant and had done nothing that it was involved with a testing of his mental retardation. To me, an indication that the prosecutor was really, as Mr. McMillan said a while ago, interested in winning and winning alone, and unable to accept the fact that perhaps he should not win. Now, these are the arguments that came later. Recall what I said about the organic brain damage and the fact that the doctor apparently stumbled when he walked out and got down from the stand. Here's the prosecutor's argument. But now you have additional input, talking about the fact that there was no defense evidence in the trial. You have some of defendant's evidence to weigh and to determine whether you should believe all or none or part of it. Then you look to what you looked at in the state's witnesses, and he goes on and talks about the opportunity of the witness to see, so on and so forth, and to know the manner and appearance of the witness whether they got a dry throat, and the doctor apparently kept drinking water during the course of his testimony, and needed water to choke out some of their answers, whether they smiled at inappropriate times, and at some point during his cross-examination of the doctor, he had asked him what he was smiling about, whether they stumbled off the stand, which might show some neurological dysfunction. You had a chance to observe that, and you had a chance to observe any interest or bias or prejudice that anyone might display, like getting paid to be here. And he had made a big to-do about the payment of the doctor. He goes on about the doctor. Not one shred, not one mote, not one atom, not one scintilla of evidence that he, the defendant, was under any mental or emotional disturbance on the 18th of December, 1996. The only evidence at all is that from Dr. Nothing in these records about any prior psychiatric evaluation or treatment. Where do you think that came from? That came as a mitigating, you know, he said, at least he's honest when he says that I was hired to look into mitigating circumstances. That is to cook up some. He goes on, and y'all might think that this is perfectly fine. I find it astounding. But you know, just because Dr. Short gets up here, excuse me, I've used his name, and parrots it, it doesn't make it, he doesn't like to testify in these cases anymore. It doesn't make it so, because we know he'll say anything for money. He'll say anything. You just name it. You just put in the form of a yes or a no question. If his throat is too dry, he'll shake his head. So you just hang your credibility on Dr. Short. He'll tell you. Well, I can go on because there are other parts of this, but I think you get the gist of it, that the adversarial ethic has allowed this particular prosecutor to believe that he can go to any length to get his, not only his conviction, but his death penalty, and he did. What I would like for us to do as a bar is basically begin to discuss what it is that we as lawyers ought to be doing, whether there is some part that the common good should have in our activities. And let me say that I am probably the only kind of negative person up here. I admire and acknowledge the great good that lawyers do. It's just that I think that at sometimes, and I think I almost started this presentation by saying, without showing hands, how many of you in an adversarial situation have ever done something that you are a little bit ashamed about? I know that I can probably say that I am, because I just got, too into it. I think we need to have a discussion, a continuing discussion about our role as advocates and our communities. Not that we need to sell out our clients, but that we need to put some restraints on what we're doing. What was crucial to the Republicans' claim, and what remains crucial today, is not the existence of a consensus on particular moral or legal issues, but that a public conversation occurs which includes prominently arguments about what would be good for the community as distinguished from arguments about the rights of individuals. And as I point out in my paper, I would redefine this by saying that we should have a public conversation about the common good as it relates to the rights of individuals. I am certainly not promoting the giving up of individual rights. But I think this is where the tension lies. This is, to some extent, where we get our bad name. And I encourage the conversation. Now, is my time up? Thank you. Thank you.
Thank you, Judge McCrodden. I'm sure you've given us all a lot to think about. Our final speaker today is the Honorable Donald W. Stevens. He is the senior resident Superior Court judge in Wake County, and he is going going to talk with us today about the enactment of the new local rules for Superior Court, particularly the ethical and professionalism motivations that caused the enactment of those rules.
You know, when you sit up here on the panel and you're thinking about what am I going to say, and you're trying to listen to what everybody else says, and you write things down when in response to remarks of the other panel members. When Roger spoke, and I love Roger, I wrote down, so those of you who don't drink coffee are really in trouble. Lonnie Coleman, a real fine trial lawyer out of Orange County for years and now district court judge over there, had another rule, Roger. He had a rule that said, don't ride to the courthouse with your client. Lonnie represented a lot of people charged with drug trafficking, and he said, if you ride to the courthouse with your client, you're liable to get busted when they get busted. So that's another rule. Don't ride to the courthouse with your client. Interestingly, my topic this afternoon is not about criminal cases, although I came to the trial bench from the rough and tumble of the criminal courtroom. I'm here today to talk to you about civil matters. And frankly, in 1984, when I became a Superior Court judge and came out of the rough and tumble of the criminal courtrooms, I had the impression that the trial of a civil case was a rather pristine, genteel proceeding, above the fray, no rudeness, no hostility, and found out very quickly, obviously, that the prosecution and the defense of civil cases is quite frequently anything but civil. At the call of the calendar on Monday morning, I sometimes ask myself, when you stand up and tell me you represent the plaintiff or the defendant, why are you here? Are you here to make war, or are you here to make peace? Are you a gladiator, or are you a peacemaker? And generally, frankly, at the end of the day, the most successful lawyer that I see in my courtroom, in my opinion, is the peacemaker with a sword. So I suggest to you this afternoon that if you strive to be anything in a civil case, you should strive to be a peacemaker with a sword. And drink coffee. We've got a few minutes, and I know the people that planned this program said to themselves at 4:45 in the afternoon, Don Stevens can talk about the new local civil rules, and no one will dare stand up and leave while their senior judge is discussing this exciting topic. They did not include me in this decision. If they had, I would have said, oh, please. Is Greg Stott here? I would have said, Greg Stott will let me get about 2 minutes into this presentation. He will get up and he'll say, hell, I can read. And he'll walk out. So, since Greg's not here, I'm sure there's probably a patriot out there somewhere who will be a worthy substitute. So we'll all wait and see who that's going to be. When I came to the Superior Court bench, I was kind of troubled trying to figure out how civil cases sometimes can be so uncivil, and how criminal lawyers seem to get along with prosecutors with criminal lawyers. It was pretty obvious along the way that the reason is that most of what happens in a criminal case happens in a courtroom with some degree of judicial supervision. Most of what happens in a civil case happens outside the courtroom without any kind of judicial supervision. And we somehow or another expect ourselves to be governed by rules of civil procedure and some kind of a honor system that we call our rules of professional responsibility, which rules frankly have very little impact on those who are without honor and those who are devoid of any professional standards. These rules and this discussion today, I think most of our comments are really not directed to the people here. They're really directed to the people who aren't here. We are preaching to the choir, and we know that. But I would invite your attention to the fact that these rules are written for the benefit of the ethical lawyer, so you can use them to protect you from the unethical lawyer, the lawyer without civility, the lawyer without any professional standards, and that we will help you do that if you ask us to. Jim Ferguson, who's a fine trial lawyer, has a favorite topic, and I've heard him speak on it before. It's entitled Civility as a Tool of Advocacy. Think about it. Civility as a tool of advocacy. If you think about, with rare exception, our most successful trial lawyers, people like Wade Smith, Roger Smith, people like the late Bill Thorpe, people like John Edwards, who's gone on to do other things. Except for their gift of speech, their greatest gift, in my opinion, their greatest tool was their humanity and their civility. Being nice, frankly, folks, is a tremendous tool of advocacy. In fact, I love to hear Wade Smith talk about his practice when his adversary insults him, to reach in his wallet and pull out $1 and hand it to him and say, you know, obviously something's going on wrong in your life, and I just want to do something good to help you. It is absolutely disarming. Or, if he's prepared for the situation, he can have prepared a thought for the day to hand to his opponent, or a scripture verse to hand to his opponent. It's amazing how disarming that is. It's also amazing how likely you will not be re-insulted, because they don't want to be handed another scripture verse or another dollar bill in the presence of a group of people. It's embarrassing. The whole effect of the insult is back in their face. I do believe that, and I agree greatly with Jim Ferguson, the great tool of advocacy includes, as one of its finest traits, civility. Certainly you can have civility without excellence, but you will never have excellence without civility. If you can convince a jury that you're a good person, they have a hard time, and they like you. They have a hard time coming back in the courtroom and looking you in the eye and ruling against you. You can hold your damages down in a case in which you're going to get hit with damages, or you can jack your recovery up in a case in which you're going to win, because the jury likes you, they respect you, they respect how you respect everybody in the courtroom. And you can't make it up. It's got to be genuine. It's got to be obvious. I mean, it starts from the day you walk into the courtroom, and not just in your closing statement to the jury. So, if you ask me why should I be civil, because it is a great tool to your benefit, and it costs you absolutely nothing. So, you know, civility is things like, how about giving the other side a call before you notice the deposition for a time inconvenient to them? I mean, what's wrong with that? How much trouble is that? How much trouble is it to tell the defense attorney on Friday that you're going to take a voluntary dismissal on Monday of your case, and then you refile it later, so they won't spend all weekend getting ready to try a case that you know will not be tried? How much trouble is it to, as a defense attorney, to tell a plaintiff's lawyer, we're going to stipulate to liability, so they won't spend all weekend getting ready to try a liability issue that you know won't have to be tried? I mean, how, that's just courtesy. That's just good old-fashioned being nice. And I assure you that it impresses the people in the courtroom and impresses the judges when they look at the file and say, you know, you're stipulating the liability, aren't you? Well, there's no liability issue here, is it? Or you're not proceeding on this punitive damage claim, are you? There's no punitive damage claim here. Clean it up. Be responsible. Be professional. That's the way in which good lawyers are successful, and that's the way the practice of law is done. Civility includes, as we all know, you know, returning phone calls, being professional, not playing stupid word games. When the request for production of documents, you answer and say that the plaintiff is not presently in possession of those documents, even though you know where they are. Maybe they're in your vault or in somebody else's possession. And that'll come back and bite you. If you aid and abet a party in violating the rules, you yourself will be held accountable for that. And generally, it all shakes out in the end. Screaming and yelling at each other over the telephone. I am amazed at how many lawyers tell me they just had a conversation with another lawyer who screamed and yelled at them over the telephone. I am amazed and constantly amazed that our profession, that there are people in our profession, and apparently a number of them, who engage in that type of communication. Not knowing the rules, not following the rules, not knowing the law, not following the law, calling each other liars. About a year ago, I had the distinct displeasure of having two senior members of our bar, who I respected, appear before me on a motion for summary judgment based on a failure to respond to requests for admissions, in which the lawyer with a client obligated to respond contended that there had been an oral extension agreed upon, and the other lawyer contended otherwise, and therefore the answers were late, and the motion for summary judgment was filed. And they expected for me to decide which one of them was telling the truth. And I said, I will not go there. And I don't think our judges will go there. What I said was to the lawyer with the obligation to answer timely, who contended he had an extension, did you do anything to help me believe you? Did you send a letter the next day or that moment after you hung up and say, thank you for this extension? I'll return the favor to you sometime. Did you send him an email? Did you do anything in the file to help me objectively decide how to rule here? And he said no. And therefore, my ruling was what it obviously should be. I will not decide, and we should not be required to decide who's telling the truth. And it's a sad day in which that matter, with senior members of the bar, had to be heard in the Superior Court of Wake County. Don't ever let yourself get into that situation. I know the senior lawyers will tell you, your word is your bond. Your word is your bond. But send a letter. Send an email. Okay? It's a different day. And that's how you That's how you protect your client, protect your own integrity when someone says you're a liar. Otherwise, we end up in cross motions for Rule 11 sanctions and Rule 37 sanctions, all that sort of stuff. If you have a lawyer who's out of control, who shows up late for depositions, who interrupts the deposition witnesses constantly, who objects to everything, who instructs the witnesses how to testify, who tries to blatantly coach the deposition witness, who verbally attacks and abuses the deposition witness, who constantly uses profanity before, during, and after a deposition, who extends a deposition beyond any reasonable time period. Ask us to help you, please. Otherwise, and I'm afraid the tendency is to say, if I can just get this case over with, honestly, I'll just never be involved with that lawyer again. It won't be my problem anymore. But the problem is, it will be somebody else's problem, and you need to help enforce these rules of simple decency for our profession, please. If you have to make a motion under Rule 26F, that's a motion for a discovery conference and a request for a discovery scheduling order, and set forth your basis. And I, as your senior judge, will honor it. Just tell me the lawyer consistently and habitually uses profanity. The lawyer consistently and habitually is late for the hearing. The lawyer consistently and habitually does all the things that I just mentioned. And I'll enter an order that he not do that. So if he does or she does, I will have a hearing as to whether or not his or her license is in jeopardy, the privilege to practice in the Superior Court of this district is in jeopardy, whether or not their ability to continue in that case is in jeopardy, and it'll stop. But you have to make the motion. Otherwise, we will never, Judge Manning and I, and Judge Morgan, and all of our fellow judges will never know anything about it. I've got a couple of orders here that I signed, and the time is almost gone, and I haven't got to the local rules, but as Greg Stott would say, hell, you can read. I entered an order involving an attorney who failed to, who knew his client wasn't going to appear at a properly noticed deposition, so he decided he wasn't going to appear either, and he didn't. And then the opposing counsel thought there must be some communication mistake, so they called a lawyer, and they said, well, I didn't get it on my calendar, and they noticed it again, and he didn't show up the second time either. So I took the position that that's not his problem, that's not his fault. He somehow or another couldn't be sanctioned or punished, and clearly he can't be, anyone can't be who violates the rules or participates with another to violate the rules. And I did enter a sanction in that case. We can help you in cases involving collateral persons involved in the same type of conduct. I entered an order in a case involving a doctor who I will not name. Or try not to slip up in that. An orthopedic surgeon who during a discovery deposition said, can we go off the record? And the lawyer said, sure. And as soon as he went off the record, he commenced to tell both of them how stupid they were. He used profanity. He told them how idiotic their questions were, how dare they challenge his opinion. And he stormed out, to the absolute amazement of both lawyers, plaintiff and defense lawyer. And the court reporter said, he's done that before. And she said, in fact, that's the reason I left my machine on. I've got that. This is a real case, folks. I have a real order right here in front of me that I entered. What happened was the case got settled because, the plaintiff couldn't take that witness to trial. But it really bothered both lawyers. And they could have just let it go and said, well, we just won't ever use him again. And they came to me and they said, what can we do? And I said, tell you what, let's treat it as a de Veniesi deposition. File a motion telling me that's how you treat it. Ask me to set a fee, or consider a motion to set a fee. At a hearing, we send him notice. At a hearing, in which I determine whether or not he should be awarded a fee. At that hearing, I entered an order, not only that he should not be awarded a fee, but I entered an order that said that, and I won't read it all, but just the important stuff, that he had conducted and demonstrated himself in such a way as not to possess the professional maturity, balanced judgment, reasoning, and professional courtesy necessary to qualify as an expert witness in this or any other matter in this court or any other court in the state of North Carolina. And notified them to send him a copy. 3 weeks later, I had a call from a lawyer who represented this doctor who wanted to know how I could get this order stricken. Okay, hey, we can make a difference. We can clean up everything. We can clean up people in the system who think they can make their own rules and follow their own rules. But you have to help us. And we, actually I entered an order modifying that order after the doctor agreed to mental health counseling, agreed to have his own lawyer on staff, and therefore if he had any available to him during any deposition, or if he had any question about the right of the lawyers to ask him those questions, that he could stop and consult with his lawyer before he would answer any additional questions in the matter. And we made some progress. But again, these are things that you have to let us help you do in making sure that the system in our profession works the way it ought to, the way we want it to, the way it's been envisioned by the people who talked to you during the course of the afternoon. Let me talk to you now about, for 5 minutes or 2 minutes, 3 minutes, whatever we got left, about our local rules. And I think that they're sort of self-explanatory. I would hope that I wouldn't have to explain them. But I really want to tell you, as Katherine mentioned, and Katherine came over and talked to me one day for about an hour or two about why we wrote the rules the way we did. And based upon what I said, she wrote this paper. The information is correct, and I really appreciate her writing it down to tell you why we felt like we needed to make these rule changes. And Sally Kearns is very much involved, as were some of our other judges. Judge Manning very much instrumental as well. There were 2 goals to the rule changes. The first goal that we had was to balance the playing field. Stop judge shopping. About 2 months ago, shortly after the rules went into effect, there was a civil action filed by a general contractor against a developer, and also a claim of lien pending in that matter. At the same time, before the clerk of the Superior Court, there was a foreclosure proceeding in progress because an insurance company had funded the development for about $20 million. The loan was in default. The interest was accruing at about $6,000 a day. No payments were being made. And the insurance company had decided to foreclose on that development loan, construction loan. The general contractor was not a party to that foreclosure proceeding before the clerk, but had been given notice of the foreclosure proceeding. A day before the foreclosure proceeding was scheduled to be held before the clerk, a lawyer on behalf of the general contractor in this other lawsuit appeared before a judge of the Superior Court who was actually holding criminal court, and that lawyer presented that judge with 2 motions. The first motion was to intervene in the foreclosure proceeding, over which the judge, in my opinion, had no jurisdiction. That motion was allowed. without notice to the parties of the foreclosure. The second motion was to stay the foreclosure proceeding. That motion was allowed. And the parties to the foreclosure proceeding were then notified that their action had been stayed. $6,000 a day interest was accruing. No bond was required. The stay was indefinite, pending the outcome of this other civil proceeding. No preliminary hearing was required. And that order was simply sent to the party. The insurance company and the developer, well, the insurance company primarily, called our trial court administrator and said, "How can that happen?" And she said, "It can happen." But it in fact did happen. So the parties, at her instruction, there was a motion filed for the court to allow consideration of a relief from the stay. So the parties would at least have an opportunity to be heard. I conducted a hearing, determined that the judge had no jurisdiction, that his decision to allow the motion to intervene in the matter before the clerk was advisory only, which the clerk could ignore or accept as the clerk deemed appropriate. And also, since the stay order was not supported by a bond, there was no notice and no preliminary hearing set, that it was of no legal effect, and it expired after 10 days anyway. And then ordered the foreclosure to proceed. Today, in our district, hopefully, for the purpose of our rules, which now require, and have since May the 1st, that everything be filed with the trial court administrator, that everything be assigned by the trial court administrator, that the trial court administrator, not the parties, decide what judge hears any matter on the civil, pending in our civil proceedings. Hopefully that will not happen again. It should not have happened in a desire and intent that it not happen. And that whether you've been practicing law in Wake County for 40 years or 4 months, the playing field should be the same. You should have an opportunity to have a fair hearing in front of an impartial magistrate who hears both sides and renders a decision accordingly. That is the purpose, and the main purpose of the requirement under our rules, the trial court administrator assign every matter pending in Wake County. Hopefully, the day of judge shopping is over. The second purpose of the rule is to eliminate what I would probably like to call the sucker punch. The TRO that gives somebody an undue advantage. Historically, judges have been presented with TROs, requests, with little or no information, in a very unbalanced way, and probably in a way in which they've had little or no time to deal with an important matter. They have either, and we're all guilty of it, we've either not asked the right questions, or not known what questions to ask, or not known exactly what we had before us. And we may well have entered some orders that were imprudent and inappropriate. So, under our local rules, as you all now know or should know, there is an obligation, if you're seeking a TRO, to notify the other party of your intention to seek a restraining order, and we will allow the other party to be present, not to hash out the merits of it all, but to be able to answer those questions that the judge may ask, such as, will this put the other side out of business? What kind of damages do you think that they may suffer? Is this really necessary? And you're always asking the wrong party when you're asking those questions. You're asking the party that wants you to allow the relief. We have found already that we are less likely to impose entirely restrictive restraining orders that we traditionally impose. We are more likely to be reasonable about an appropriate bond, and we frankly, get the parties off to the right start. We don't have a sucker punch in which somebody feels like they're already at a disadvantage. The TRO is a catalyst to fuel the aggravation of litigation if it's obtained in that way. It does nothing to facilitate settlement or civilized discussion of the matter in controversy. We have found a new rule brings the parties together, that actually sometimes that they'll come to us and say, we've already got it resolved, we've already decided the manner in which the status quo will remain, and we think it has had a very good effect. And you would all note, I hope, that as of October the 1st, the legislature has changed Rule 65 of the Rules of Civil Procedure in any event, which requires that you certify that you have made an effort to notify opposing counsel or opposing party of your intention to seek a restraining order, or you need to set forth the reasons why you have not notified them because of some emergency situation. We feel like these new rules will add some civility and eliminate some fuel that generally fuel litigation as opposed to help resolve it. I would encourage each of you to be a peacemaker with a sword when you read our rules, and if you need help, we'll be the first to try to enforce them for your benefit. Thank you.
I'd like to thank all of our speakers today for sharing with us their experience, their insight, their wisdom, and their inspiration. I know this has certainly been inspirational to me, and I hope it has been to you as well. I'd also like to thank you all for coming. I also want to mention we do have a small token of our appreciation for the people who were kind enough to come here today and speak from the Wake County Bar Association. Thank you all for coming. Appreciate it.